Welcome to Community Legal Education Association's Legal Information for Tenants in Manitoba video series. This video is about tenant safety and what to do if you have disruptive or concerning neighbors. This video was produced by Community Legal Education Association Manitoba, or CLEA, with funding provided by Justice Canada. CLEA is located in Winnipeg, Manitoba on Treaty 1 territory, the traditional gathering place of the Anishinaabe, Cree, Oji-Cree, Dakota, and Dene peoples, and the traditional homeland of the Métis people. Our water is sourced from Shoal Lake 40 First Nation. We acknowledge that much harm was done in the past and continues to be done. Therefore, we dedicate ourselves to moving forward in the spirit of reconciliation. This video contains information about Manitoba laws and is only intended for Manitoba residents. This video contains general legal information only and not specific legal advice. For legal advice about your specific situation, speak to a lawyer. Tenants should expect a safe and comfortable place to live. This also means privacy, peace, and quiet. You should not have to deal with dangers in your living space and common areas. There are laws about what tenants can and can't do, and most landlords also have additional house rules that their tenants have to follow. By law, house rules must be reasonable. For example, a landlord likely could not have a house rule that bans all guests. If you are renting and there are serious problems with your neighbors, be aware that there are often solutions. There are steps you can take to get the help you need. This video will walk you through some of the most common problems that renters face in dealing with noisy or worrisome neighbors. We'll show you what you can do to try to improve your living situation. If these things don't work, you will also learn how you can legally end your lease early and move out. Tenants and landlords both have legal rights and responsibilities. You may have a written tenancy agreement, which is the rental contract, also often called a lease. The landlord and tenant's rights and responsibilities are listed on the Residential Tenancies Branch Standard Blank Lease Form. You do not have to use this form or even have a written tenancy agreement, but many landlords do use this form. The Residential Tenancies Branch is a government body that provides information to both tenants and landlords about their rights and obligations. The Residential Tenancies Branch also investigates matters between tenants and landlords. It is important that before you rent a place to live, you read the tenancy agreement carefully so that you understand your rights and responsibilities as a tenant. If your agreement does not include this information, or if you don't have a written tenancy agreement, you can visit the Residential Tenancies website to learn about your rights and responsibilities. Tenants are also held responsible for what their guests do. Tenants must not disturb others in the building or in a building next door. They can still do normal activities like talking and listening to music, but the noise level must be reasonable. This may depend on the particular situation. A person might be able to jump rope at 9 in the morning without disturbing anyone, but not at 2 in the morning when most people are sleeping. It would also depend on the building's characteristics, like how thick the walls are and how much noise travels between suites. The law also says tenants must not endanger the safety of others in the building or create unsafe situations. Some examples of creating unsafe situations are blocking hallways or stairwells with bicycles or other belongings, being careless when smoking or cooking, or letting pets free in the building. The law also says that tenants can't damage the complex or unit, can't harass or threaten others in the building, can't interfere with the enjoyment of the complex or a unit by others in the building, for example, by being noisy or having noisy parties. And they also can't let people into the building who do any of those things. If a tenant or a guest of a tenant is causing any of these problems in your building, you can make a complaint to your landlord and you should expect to get some help. You should document incidents, dates, times, and a description of what happened. If you're afraid for your safety, you may also want to call the police. By law, if a tenant complains about being disturbed or complains about someone interfering with their safety, the landlord has to investigate without delay. The landlord also has to take some action to try to solve the problem. Sometimes these problems can be solved in simple ways, especially if they are related to noise. For example, the landlord can speak to the neighbor making the noise, install carpet to reduce noise for a downstairs neighbor, or post reminders about the noise rules. The landlord can also give the noisy or disruptive tenant a warning. If a problem caused by another tenant keeps happening, the landlord can evict the tenant, even if it is the tenant's guest who is causing the problem. If your landlord does not deal with the problem, you can contact the Residential Tenancies branch. The Residential Tenancies branch has offices in Winnipeg, Brandon, and Thompson. You can call the office closest to you or visit in person during business hours. The first step is to speak to an officer. The officer may ask you to participate in mediation with the landlord. Mediation is voluntary, and the tenant and landlord must both agree to participate. In mediation, the landlord, the tenant, and a mediator discuss the situation together and try to agree on a solution. If you or the landlord don't agree to participate in mediation, the branch can make an order for the landlord to investigate the problem. If the landlord still doesn't investigate, the landlord is breaching the tenancy agreement. In that case, you can make a written demand for the landlord to investigate, and if they still don't, you can end the tenancy agreement by giving notice of one rental payment period. If there is a risk to your health or safety, the notice period is only 5 days, and you don't need to give the landlord written notice to remedy the situation. If your unit is uninhabitable, meaning you cannot live in it, then no notice period is needed, and you also don't need to give the landlord written notice to remedy the situation. You can also make a claim for compensation for certain kinds of losses if you have to move. In this situation, however, the tenant has a duty to minimize their losses. For more information, visit the Community Legal Education Association's website at www.communitylegal.mb.ca.